A very warm welcome to everyone, and thank you for joining us at this presentation on how to start a business in America as a non-US citizen. My name is Ancy Varghese. I'm a US immigration attorney at the VisaPro law firm. I practice primarily in the area of US immigration and naturalization law, with expertise in employment-based matters. Foreign nationals who want to open a new business in the US and would like to live and work here have several interesting options, including the L1, the E2, the EB1, and the EB5. In today's program, I'll show you how you can formulate successful immigration strategies to set up and manage a new business in the US, utilizing a visa strategy tailored to your needs. We have a lot of great information that we want to share with you today. Let's go ahead and get started. We'll begin with the basics of setting up a business in the US. Let's take a quick look at the practical aspects of how to start a business in the country so that the proper foundation is made for a subsequent visa application. The first step in the process is incorporating your business. Selecting the most suitable legal business structure is the first and foremost step in starting a business entity. There are four main types of business entities in the US: sole proprietorships, partnerships, limited liability companies or LLCs, and corporations. Choosing which structure is right for you will depend on various factors, including the capital involved, the nature of the business, the nature of ownership, legal formalities involved, tax issues, both at the federal and state level, and management and control, among other factors. Next, you'll want to pick a location for your business. Unlike most foreign countries, corporations and businesses in the US are almost exclusively regulated at the state level by state laws. While incorporating in the state where you will live or be most active may seem like the obvious choice, you may have to examine tax issues and other corporate reasons to incorporate in one state and have your actual headquarters in another. Finally, you'll also need to determine the ownership structure of your company. The ownership structure of your new company can be a critical factor in choosing the correct visa options for you or for your employees down the line. In the case of an L1 visa, for example, an appropriate qualifying relationship, that means a parent subsidiary, a branch office, or affiliate relationship, must exist between the US company and a foreign company abroad. In the case of an E2 visa, on the other hand, the US company must be at least 50% owned by a national or nationals of certain predetermined countries. When establishing a US company with a look to future visa possibilities, you must ensure that the ownership of the US company is suitably structured to meet the requirements of the desired visa option or options. Now that you've formed the US entity, what's next? You'll need to secure an employment identification number, also known as a federal tax ID number, for the new company. The FEIN is used to identify a business entity for tax-paying purposes by the Internal Revenue Service at the federal level and by state taxation authorities. You'll need to open a bank account for the new company and capitalize the account. And you'll need to secure a physical office space for the new company in the US. Let's now take a look at the two most popular US short-term visa options that can be used to start and build a business in the country: the New Office L1 and the E2 visa. The L1 visa is a non-immigrant visa classification available to employees of international companies who are being transferred to their US office. To qualify for the L1, there are certain requirements that must be satisfied. The new US company must have a related foreign entity abroad. The US and foreign entities must have a parent subsidiary, affiliate, or branch office relationship to each other. The person being transferred must have been an employee of the foreign company for at least a year within the past 3 years as a manager, executive, or specialized knowledge professional. And finally, the person coming to the US must be employed in the related US company as a manager, executive, or specialized knowledge professional. The L1 visa category is divided into two categories: the L1A and the L1B. The L1A is for executives and managers, and the L1B is for employees with specialized knowledge. Let's now take a look at what makes the subcategory of the New Office L1 visa special. The L1 new office visas are available to employees being transferred to U.S. companies that have just been established or have been doing business in the U.S. for less than 1 year. In addition to the requirements we discussed, to secure a new office L1 visa, a few additional requirements have to be met. The new office should have enough capital or access to capital to fund its first year of operations. For L1As, you need to be prepared to show that the new office will require and support a manager or executive within 1 year. You're going to need a good business plan. For new office L1Bs, you have to be prepared to show that the new office can support the specialized knowledge professional within a year. For starting a business in the U.S. as a foreign national, the new office L1 is a great option. Let's switch gears now and take a look at the E2 visa category. The E-visa is generally available to citizens of countries that have treaties with the U.S., also known as treaty countries. There are actually 3 types of E-visas, the E1, the E2, and the E3. Our focus today is going to be on the E2, which is the most popular option for foreign national investors, entrepreneurs, and executives. The E2 treaty investor visa allows nationals from countries that have treaties of commerce with the U.S. to enter the U.S. for the purpose of directing and developing the operations of an enterprise they have invested in, or in the process of investing a substantial amount of capital. In addition to the principal investor or investors, E2 visas are also available for essential employees or managers as long as they are citizens of the treaty country. To qualify for the E2 classification, the U.S. company must be at least 50% owned by national or nationals of a treaty country. If the U.S. company is owned by another entity, then that entity must have the requisite treaty country ownership. The applicant must be a citizen of the qualifying treaty country, and to qualify as a principal investor, the applicant must have invested in or be actively in the process of investing in a substantial amount of capital in a bona fide enterprise in the U.S. and be seeking to enter the country solely to develop and direct the investment enterprise. To qualify as a manager or essential employee, the applicant must meet the definition of employee under relevant law and must plan to engage in the duties of a manager or supervisory character, or if employed in a lesser capacity, must have special qualifications, respectively. Remember, there's no set minimum amount that qualifies for a substantial investment. For the E2 visa, while you may hear that the minimum investment amount must be something like $100,000, that's not necessarily true. The amount invested should be proportional to the cost of the business, sufficient to show the investor's commitment to the business, and of a magnitude which ensures that the business will succeed. So is there a way for nationals of non-treaty countries to obtain an E2? Here are a few alternative ways to obtain an E2 visa if you're a citizen of a country like India, China, or Brazil, which doesn't have treaties with the U.S. Remember, eligibility for the E2 visa is not based on where you're born, but your country of citizenship or nationality. This means if you have dual citizenship or can acquire citizenship of a treaty country, you may become eligible for the E2. To obtain the E2 visa, for example, investors can acquire citizenship through investment in a treaty country like Grenada and then pursue investment in the U.S. You can also try to set up a business and the E2 through your spouse if he or she has qualifying citizenship. Regardless of your own citizenship, you'll be able to qualify for the E2 dependent visa and a work permit once you reach the U.S., where you can run the business with your spouse. So we've briefly outlined the L1 and the E2 visa. While they share several commonalities, these two categories are still vastly different. Understanding these differences will help you choose the visa option that's right for you and your employees. The L1 visa, for example, requires that the U.S. company have a related company abroad, a parent, subsidiary, or branch office. The E2 has no such requirement. On the other hand, the E2 visa can only be used by citizens of countries that maintain a bilateral investment treaty with the U.S. There's no such restriction for an L1. For an E2 investor visa, the investment involved must be substantial. The new Office L1 only requires that the company have access to enough capital to run initial operations. To qualify for the L1, the foreign national must have been employed for one continuous year within the last 3 years in an executive, managerial, or specialized knowledge position. There's no such requirement for the E2 visa. And finally, E2 visa applications are usually processed directly at the US Embassy or consulate and can take upwards of 6 to 12 weeks to process with practically no provision to expedite. An L1 visa petition can take as little as 2 to 3 weeks with premium processing at the USCIS service centers. Both the new Office L1 and E2 visa can also be used to bring technical employees to the US. There's no requirement for you to have to use only managers or executives to start operations in the US. Now, for those interested in a more permanent or long-term green card option, there are several paths to the green card, but the two most popular paths for investors and entrepreneurs are the EB1C and the EB5. The EB1C for multinational manager and executive transferees. The EB1C green card for multinational executives and managers offers a direct path for both L1 or E visa holders, as long as there's a qualifying multinational company abroad and the applicant served in an executive or managerial capacity, both in the company abroad as well as the US company. Additionally, potential applicants can apply for the EB1 green card directly. There's no requirement to do the L1 or E2 first. The EB5 Immigrant Investor Program. The EB5 is available for foreign entrepreneurs who invest $1.8 million in a commercial enterprise that will benefit the US economy and can create at least 10 full-time US jobs. The investment amount is reduced to $900,000 if the commercial enterprise is in a targeted employment area. Interestingly, investors can become eligible for the EB5 if they can show that they have invested the requisite amount of funds over time, as long as he or she can show that it's their personal investment, not reinvestment of company assets or profits. Now, keeping in mind the current extraordinary time, let's take a quick look at a key COVID-19 related impact on L1 visa process. President Trump's proclamations limiting immigration into the US were released on June 22, 2020, which suspended the entry of certain foreign nationals on H1, H2, L1, and J1 visas and their dependents until the end of this year. The suspension applies only to those foreign nationals who are outside the US and didn't already have an appropriate non-immigrant visa as of June 24th. Earlier proclamations restricted the entry of those from China and the Schengen countries, as well as the UK and Brazil. It's important to note that the proclamation does not impact travel on a B1 business visitor visa or traveling to the US under the visa waiver program for business purposes, unless you're coming from one of the affected countries. Foreign nationals seeking short-term entry into the US to engage in legitimate business activities may continue to seek admission into the US under the B1 or visa waiver. Additionally, the following class of L1 visa holders are also excluded from the proclamation. Foreign nationals coming to the US to provide temporary labor or services essential to the US food supply chain, foreign nationals whose entry is determined to be in the national interest, including those critical to defense, those involved with medical care of individuals with COVID-19, those involved with COVID-19 medical research, those whose activities will facilitate the economic recovery of the US, or those whose children may age out due to the proclamation. Finally, Canadian nationals are also exempt from the proclamation, restricting the entry of L workers, as they don't require a visa and can apply for entry into the US directly at the port of entry. With that, we've come to the end of this presentation. I want to thank Softland Expo for hosting this session and providing us an opportunity to interact and learn from people like you. I look forward to interacting with you and answering your questions during the live session.